Judge Staten, good to see you. I appreciate you doing this. Good afternoon, or as I would say at EBC, what's up? My name is Anthony Trufant, and I have the privilege of being the senior pastor of Emmanuel Baptist Church. During the course of my almost 31 years here, EBC has always been involved in the larger community, both locally and globally. We have made sure that we participate in programming that meets the needs of people who are in the African diaspora, both those in the Big Apple as well as those who are well beyond the Big Apple. One of the things that I love about EBC is that EBC, during my tenure and even prior to my tenure, has always been engaged in the community, has always stood in the public square, and has always had a heart, not only for helping the community, but helping the community in particular ways, not simply by community outreach, but by community empowerment. And so on today, we will have a conversation that I think is crucial. And let me offer you a case in point. This is our second conversation entitled Reclaiming Our Right to Breathe. And it's one that was triggered by what we witnessed last year. The horrific and tragic deaths at the hand of police was something that I have to admit to you, I found to be incredulous and I found to be angering. It pulled at my heartstrings, but it also pulled at my desire to make a difference. And I reasoned that one of the ways in which we can do that is to have a conversation about not only what happens from the arrest to the arraignment, but what happens from the arraignment to the trial. And I think this is apropos given what we witnessed in the case of Breonna Taylor. Her fiance, Kenneth Walker, you know the details, was arrested and then was given a deal if he would dirty up the woman that he loved, and he refused to do so. And for a while, the prosecutors resolved to try to squeeze him, not because he was guilty, but rather because of politics. And so I think it's important that we are able to have this conversation and that we have a panel of experts that can frame this matter for us. And so I invite you to participate in this conversation, listen in, largely because this is not an abstract conversation. This is one in which you and I are deeply invested. We have skin in the game. And so I'm going to ask now that we have a quick word of prayer, and then we will begin. Oh God, as we gather today, and we do so not in person, but we do so by virtue of the miracles of technology. We're thankful for whoever it was that invented this technology. We're thankful for whoever it was that gave us the capacity to connect through Zoom. We pray now, God, that we will focus not on the technology, but that we will focus on your truth. I pray that the panelists will teach us what we need to know and what we need to do. But equally important, may they find us to be attentive, involved, and pleased by what they have heard and experienced. Finally, oh God, be with our, our team that is facilitating this experience. This, oh God, is our prayer. We ask this in Jesus' name before it's called and pray. And the sons and daughters of God said, amen. Amen. It is now my distinct privilege to introduce to you our host for this event. Jocelyn Walters is a member of EBC. She is heading up EBC DC, and we are expanding. And I appreciate the fact that she has opted to be the founding member of EBC DC. And we have people who are in the DC, Metro DC area, and I suspect that they'll be joining her. But we have her on the call, not because she's a founding member of EBC DC, but because she is the founder of our social justice ministry, Impact. And she has indeed made an impact in our congregation. And I am just grateful to God that she's here with us. And so without any further ado, I ask that you give it up for Ms. Jocelyn Walters.
Thank you so much, Reverend. I want to thank EBC for, again, creating this opportunity for us to continue to have these discussions, both thanking you and Executive Pastor, Reverend Sharika Newton, and all the ministerial staff, as well as the members, because EBC has always continued to be a place that embraces this conversation and social justice as a whole. As Rev mentioned, Impact is a Christ-centered social justice ministry. We have over 80 members and regularly have people who involve themselves in the work that we do. And so for today's conversation, as Rev mentioned, we're going to be talking about moving from arraignment to trial. We have a number of people that are esteemed panelists that I will introduce in a moment, but you can also add your questions into the Q&A so that when we get to that phase, we can also surface the things that you want to know. So first, I'm going to introduce our Brooklyn District Attorney, Eric Gonzalez. He is a lifer as far as his time in Brooklyn. And one of the things I love is that he lives and serves close to where he grew up. So he's not someone who is not walking the walk. He earned his degree in 1995 and began his career at the Brooklyn District Attorney's Office, where he ran was involved with multiple units in different types of cases. But many of the things he's focused on has been around bail reform, young adult court, non-prosecution of marijuana and possessions, as well as pre-court diversion program, something that I'm very specifically interested in at all times. And his focus has now been centralized in what's called the Justice 2020 initiative, and that's where he's been carrying out that vision. So if you're interested in learning more, that's posted on their site. You can Google it and learn all about the 17-point action plan that him and his team have put together. He's worked closely, as you can see, with faith-based institutions, law enforcement, and formerly incarcerated individuals to make sure he's hearing from the community. And then he's gotten his degrees from both University of Michigan Law School, as well as Cornell University. And he is the first district attorney of Latino descent in New York. So he sort of set some records there as well. So thank you for making the time to join us. And I'll let you introduce yourself a little further as we get into some of the questions. I next want to introduce the very honorable Betty Staten. She is a former family court judge. She spent almost 20 years, 20 years on the bench, retiring in 1979 from the New York State Family Court. And she returned to where she started at Bed-Stuy Community Legal Service Corporation, where she is currently the executive director. The thing that I find so remarkable is talking to Judge Betty is literally a walk through African-American experiences. And if you ever get the chance to sit down with her or read about her, take it up because you really will learn a lot. There's a fantastic article about her in bkreader.com where you can hear more about her story. But she has always combined social services, social justice, and the law in her career. She prioritizes outreach to schools, senior citizens, youth centers, and others. She has served as an adjunct lecturer at several colleges, including Medgar Evers, College of New Rochelle and the New York City College of Technology, where she taught business law for 15 years. She's a longstanding member of Emmanuel Baptist Church, where she helped to organize the legal ministry. And she's also a servant leader for the hospitality ministry and Primetime. And so we welcome you, Judge Betty, and we look forward to hearing from you more as we get into the panel discussion. Next up, I want to recognize Assistant Prosecutor Sherry Stembridge. She works in the New Jersey Essex County Prosecutor's Office, and she has experience at the county and municipal levels in New Jersey. And this includes prosecution of criminal cases as well as traffic and DWI. She is a licensed lawyer in New York and New Jersey, including New Jersey's federal court and the United States Supreme Court. She has degrees from University of South Carolina, Columbia, and the University of South Carolina School of Law, and participates in the National Black Prosecutors Association. She joins me in being a proud member of the Total Praise Choir as well. Next up, so we welcome you, Sherry. We also want to recognize Attorney Delorny Namorin. She is an Associate Appellate Court Counsel at the Legal Aid Society Criminal Appeals Bureau. She earned her degrees from Florida International University and the City University of New York School of Law at Queens College. She is currently, as I mentioned, a staff attorney at the Legal Aid Society of New York, where she represents defendants on direct appeal in New York State immediate appellate courts and in Supreme Court. Her work has centered around sex offender cases, so she's a great deal of knowledge there, which we will talk about. She has also previously served as a staff attorney for Neighborhood Defender Service of Harlem and a compliance officer for the 2015 New York State Attorney General. Delorny is an active member of the EBC community, and she is a member of the 2030s ministry, where she provides collaborative social and faith-based experiences to her peers. And lastly, I want to briefly introduce Brooklyn native and EBC member, Mr. Ronald Logan. I'm not going to go detailed into his story because you're going to hear it directly from him, but he was a system analysis prior to serving in the carceral system. He has, since his release, he has been working as a case manager for an HIV program at Methodist Hospital. And he will be, again, sharing more about his background shortly. So I thank all of our panelists for making the time, as Rev said, giving us your time on a Saturday, and all of our attendees for also wanting to learn more about this important part of our justice system. Before we dive into questions, I think it's important to set the groundwork of what we're talking about today. So I'm gonna call on DA Gonzalez and Sherry to sort of highlight here, what is the process from arraignment to trial? And I look at it in 3 stages: arraignment, pretrial, and trial, but maybe you can break it down for our viewers so that they have just a brief understanding of what's supposed to happen. DA Gonzalez, you can take the mic first.
All right. Well, I want to first thank you, Mr. Jocelyn, for the kind introduction to Pastor Trufant. Thank you for inviting me to participate into the entire Emmanuel Baptist Church community. Thank you to all my fellow panelists. It's an honor to be with you today. We've entered a new realm in criminal justice process, quite frankly, after the historic in the end of 2019, we passed new laws in Albany, changing the process, quite frankly, in so many different ways. When possible, so in the old days, I'll start off with what most of us are familiar with. In the old days, the police put handcuffs on someone, they took you down to the precinct, you were, booked, you were sent down to Central Brooklyn, you were charged, and at some point you were held for an inordinate amount of time in a cramped central booking room in the cells at the courthouse, and you saw an attorney, normally a public defender unless you had the means to hire a private lawyer. They told you what the arraignment was going to look like. It's going to be short. They're going to plead not guilty, and you're going to probably waive the reading of the charges. And there's really the import of that moment was about whether or not bail was going to be set. And quite frankly, that period is probably the most traumatic period in the entire arrest processing, from the moment that the police put those handcuffs on you and to the moment that you appear before a judge at arraignment. You're completely out of control. You don't have access to family members. You're normally not in constant communication with lawyers or attorneys. You only have a brief opportunity to talk to the lawyer that's been assigned to you. You don't really know them that well. So this is really particularly the most troubling period. And I think often where a lot of things go wrong, because during that arraignment, the DA's office and the DA will reveal the complaint against you, the charges against you. You'll plead not guilty, and 95% of the time, very few people plead guilty at the arraignment. But then the question of bail is set, and if you're held in on bail, it's a real hardship, and you may not be able to get out if you can't afford bail. That process was sort of upended, rightfully so, at the end of 19, and the process is supposed to look different. So if you are charged with most misdemeanor cases now, you should not have to go through a pretrial detention period. So what happens is, after the police arrest you, they're supposed to take you to the precinct, and they're supposed to see whether or not you're eligible for release on something called the desk appearance ticket. If you're eligible for release on a desk appearance ticket, you will be given a date. Normally that date's supposed to be 30 days or less to appear in court on your own. Because of coronavirus and COVID and the courts being shut, they're not even really giving dates, so they're telling you 3 months or 4 months. So the process is a little bit in flux. But the way it's supposed to work is you get a date, normally a month later, to appear in court on your own, giving you time to get your own attorney if you need an attorney, or a chance to speak with a public defender prior to coming to court. That is a tremendous improvement over the system, because you actually have a chance to talk to your attorney about what the charges are and what the risks are to you on that case. If you're not eligible for a desk appearance ticket, however, and there are some categories of misdemeanors that are not eligible, you can then be required to come to court and go through a central booking experience. Again, because of coronavirus, at the moment, a lot of those arraignments now are being done virtually. So that is also a difficult situation, because you can't have family members in the courtroom with you. You can't have support networks there at the moment of the arraignment. And quite frankly, a judge is not seeing you for who you are in the courtroom, but they're really seeing this image of you on a computer screen. It's not ideal, but that is the process to keep everyone healthy. The only benefit that I've seen to this process, besides the health implications, is that we've really reduced the amount of time people are in custody. In the bad old days, it was not unusual for people to be kept for over 24 hours before they see a judge, although the law requires people to be seen within 24 hours. In Brooklyn, on average, if you're in custody from the time the police arrest you to the time you see a judge, it's a long time. It's about 18 hours. So that fact that most people now, the overwhelming majority of people, are released without being sent to central booking is a great thing, because that really makes the process a couple of hours, maybe 2-3 hours, until Albany sends the prints. If you're charged with a serious violent crime or a felony, you will have more of the traditional process, where you will appear before the judge after being detained, and there will be a sort of a very mini hearing about whether or not bail is appropriate on that case. In Brooklyn, we've taken a lot of steps to reduce our reliance on cash bail, and the judges in Brooklyn have done a great job in normally not only imposing a cash bail amount, but alternative ways to get people out of jail, as the law now requires. So I'm going to stop there in terms of the arraignment, but really the arraignment to me is one of the most critical periods of time. And from a practice standpoint, I think it's one of the areas where defense lawyers could do more. Because during that period of time when the prosecutor is trying to bring the charges together after consulting with the police, there's often a period of time where there could be some advocacy by a defense attorney to make sure the charges are not overbroad or overborne, and also to have a little bit more advocacy about bail. Unfortunately, because most people don't have private attorneys and they're not given one until they come to court, that's a lost opportunity. But for those of you who are thinking about these issues, there's really an opportunity to get to the DA before you're charged, and that's a critical step.
Thank you so much. I'm going to ask Sherry to weigh in on just what the differences might be, and then after that, we're going to turn it over to Ronald to share his story, but I want all the other panelists to think about what are the vulnerabilities that they see, because we'll come back and talk about that a little bit after Ronald shares. So Sherry, could you share just like a few highlights? It doesn't have to be everything, but some of the main highlights that you see that are different.
Sure. So I'll actually just co-sign on what DA Gonzalez just mentioned regarding bail reform. So in New Jersey, that major change came in 2017. Where basically all bail was eliminated with the exception of like some small municipal matters. So bail was eliminated when someone gets arrested and the charges are determined. Most times they're going to be released, but the additional component is that there's what's called a public safety assessment, a PSA, that whenever someone is arrested with the system that we use, that generates a number. So it's basically a scale, real quick to just explain it, a scale where it's a determination as to whether the person is a high risk or a low risk, as to whether they will return to court. And so what happens is most of the cases, again, the person is going to be released. There's no bail. They're not going to be detained. But what happens is for the more serious cases, first degree cases, second degree cases, then there may be a presumption of detention. And what happens is when the person gets arraigned, once the person gets arrested, they'll be seen and arraigned before a judge usually within a day, but at the most 2, where the person will be arraigned, be told of their charges, and then the state will decide whether the person should be detained. So then we have to file a motion to say, why we're requesting detention of the person. And then a detention hearing is scheduled within about a week of us moving for the detention. And then at that detention hearing, what happens is the prosecutor has to put forth explain what evidence we have, whether there's video, statements, et cetera. Sometimes it gets a little detailed for the cases. So there's a hearing, a probable cause hearing, the judge makes a determination whether the person should be detained. And then if the person is detained, then we have 3 months to decide whether the person is going to be indicted or not. And if the person isn't indicted, then we have to go before, there's a presumption that they're automatically released. So if we're not indicting that person, that's the time for, the prosecutor to get their cases together, get the evidence together, determine whether this is something that case we really want to proceed with. If we don't do that, if the case is not indicted, then we have to go back before the judge and before the person is released, put it all out there to explain, why the person, why the case is not moving forward. And, it works to the person's advantage, obviously, because we have to be able to show what we have, for the case and why we're detaining this person and keeping them detained. So that's the short of it. But what I can say, though, is the little difference in Essex County, New Jersey, is that the county prosecutor's office itself has 22 municipalities in Essex. So most of the cases that we see are from Newark, East Orange, Irvington, and then the other municipalities will have, matters, but most of them are coming from those three municipalities.
Thank you so much. And what I would take away from this is that it really does depend where you are involved with the system as far as the experience that you have. But I want to turn it over to Ronald to introduce himself a little more and tell us about his story. So Ronald, the mic is yours. And I think you're still on mute.
Can you hear me now? Okay. Good afternoon, everybody. You know, my name is Ronald Logan. I grew up at Emmanuel, been going to Emmanuel since I was a little kid. Actually, Judge Staten used to be like a Sunday school teacher back in the days. But looking back in 1986, November 86, actually, I was out on Sunday and we was at a bar drinking. I went to the bathroom and a legal weapon I had discharged. As I was leaving the bar, I was approached by a gentleman, asked me if I had a gun. I'm like, no. We get into a little bit mischief going up the block from DeKalb to Vanderbilt, then around Vanderbilt. But I asked the guy if was he a cop, you know. At that point, 1986 was kind of first time I offended with a gun charge, and like we were smart. We knew we got probation or whatever behind it, you know, so there's no issue giving the cop the gun. But we got into a situation where it got to be more physical as we turned the corner. We got into a push and shoving match, and both of us wasn't a big guys. We both weighed around $150, 150 pounds or so. And as I pushed him away, he fell down. I started walking away, and I started hearing shots. And then I realized I'm buckling, but I received like 5 gunshot wounds that night, and I returned fire one time, and I hit him. They found me on Lafayette and Vanderbilt, but I understand they found him over there on Vanderbilt, close to the DeKalb. We both was in Brooklyn Hospital. They brought us both in. And after that, I didn't know what was going on. I was in the room, then the cops showed up later on. I was handcuffed to the bed, and they explained to me what was going on. And the cops that actually came through, I actually knew, and they was being very honest when me, told me what was going on. I said, okay, you know, just listen to what's happening. And I had a bedside arraignment, actually, a few days later. That's when I never went to court. They brought the judge in for a bedside arraignment. When I was released from Brooklyn Hospital, they sent me to Kings County Hospital. That's where they had the hospital ward. Then they did my surgery. Had to get screws in my knees and my left knee to hold. My kneecap was shattered. The bullet came through and shattered my kneecap. It got shot through the ankle. I received 4 wounds in my left leg, 1 in my right. So I was going through that and everything. Then on my birthday, December 6th, I had to go to court. And that's when I found out later on that day I was indicted for murder. And it was different. It was different. And then starting to go through trial. At that time, I had a paid attorney, but when you look at hindsight, and my father, we talked about it, you know, sometimes the paid attorney isn't the best attorneys neither, because what happened when you start looking back at things throughout the years that I was able to do, you see the stuff that wasn't done. Actually, the gentleman that I killed was an off-duty court officer. He didn't have no documentation on him. He didn't have his badge on him at the time. He had his gun, but no badge. We found out later on through the autopsy, the toxicology report, he had cocaine and heroin in the system. But that was never used in court. A lot of things didn't come up that should have came up that was used in court, that should have been used in court. After a while, going through court, like around 9 months went by, 10 months, it was almost a year where we finally got started trial. And during that time, they was offering me a plea of man 1, which they was offering me 8 1/3 to 25. And I wound up settling for 7 to 21. It was rough for my family. During the course of my incarceration, I lost my mother, which wasn't towards the end. We just wanted me to be home. And towards the end, I lost my mother. But the system, how can I describe this? When you look back in retrospect, it's like from the time of indictment, when everything's out there, when you look at the murder charge, murder means like you would really intend to kill somebody. The charge that I really copped out to, which was manslaughter, was actually a charge that maybe I should have been originally indicted with because of the fact I wasn't out there in intent to hurt anybody. I was just trying to defend myself. The murder intent wasn't there, but I'm not trying to justify a criminal act because it's still a criminal act. But it's just that when I look back and I think about it, more could have been done maybe from my attorney's side, from the DA side. But actually, when it was, I killed the title. I didn't kill a person because everything that was said and done, even through my incarceration, seeing the parole boards, it was emphasized on not what I achieved or whatever, but kept on going back to the title that the title that the gentleman had. Not so much of him being a human being, but it's more of a title that I killed. And I had that problem throughout my incarceration with correction officers and even with court officers when I was going to court, that they had actually had one court officer couldn't come on the floor when I was being held there for any court dates that I had because of that, because he was threatening me. So it was a rough 16 years where I had to actually learn how to become their friends, how to learn how to blend in to make them see like I was less threatening. You know, I'm not that guy no more. You know, I was never that guy, but to put a facade on who I really was to be because of the fact of the title that I've killed. And it was rough. It was really rough. And then I started hearing stories about guys that was incarcerated, working in the law library, looking over their records and stuff. A lot of Blacks are doing time for drug cases. They was getting a lot of time for drug cases where they had multiple offenses, but what happened was the cops was watching them for like days at a time instead of picking them off the street. So they just load them up. So next thing they copping up to 6 to life, 7 to life over hand-to-hand drug cases. And at that time, crack was the big thing. So everybody was getting arrested for crack. It was crack. But back to my case, it's just that I admit, I know I did something wrong. You know, it's like obvious to a duck. I know I did something wrong. I know I shouldn't have been in that situation to begin with. But the way I went through the situation was different than a lot of people. I didn't have the bullpen therapy that I've seen because our CMC was the central mind of the case. I was also able to be segregated from population, which means that whenever I went to court, I wasn't in the same, I went by van, I didn't go by bus. They had me in a separate holding cell, in a separate area. So I didn't have that kind of bullpen therapy. Yes, I had to wait in court all day like everybody else, but I didn't have to sit in a bullpen with a lot of people. You know, it's funny. It's happened so long ago, and this got me a little bit. And I've been out for quite a while. I've been out there the longer that I've been incarcerated, and it's a good feeling. But sometimes it comes back to me, and I'm grateful to have this audience right now. Just talk about it, maybe answer some questions, because I'm kind of stuck right now. And forgive me.
No need to apologize. Again, we thank you for being brave enough to share your story with us. And I would, recommend that, again, people in the audience, if you have questions specifically for Ronald, to add them into the Q&A so we can raise them up. I think it's important to acknowledge that not only is advocacy, that's the word that came to mind to me as you were speaking, Ronald, is the advocacy, whether you have committed a crime or not, we all deserve an opportunity to be advocated for in the most responsible and fair way possible. So I'm gonna actually call on Delorney to talk a little bit about the legal aid portion of this. And could you articulate for us where you see for strength and advocacy and maybe some other things that stood out to you from Ronald's story?
Hi, everybody. I hope you guys can hear me. Sorry about my voice. So my name is Delorney Namoran. I do criminal appeals for all 5 boroughs at the Legal Aid Society. And I'm not crime specific. I also do sex offender hearings. It won't come up in this panel, but I do all crimes in all 5 boroughs. And one thing about the Legal Aid Society, they have a trial department and they have appeals and a whole bunch of units. So when I heard Ron just talk about like the strength and weaknesses of a public defender, so when you once you get arraigned, if you are arraigned on a felony, Ron just talked about the grand jury. I think that's one of the pivotal points in the case is the grand jury. I'm also standing here as a person who has done grand jury in Brooklyn, and I really want to hone into the community and to people, something that Ron said, like he was indicted with murder and he probably should have never been indicted with murder, maybe just manslaughter. And I think a lot of times the joke in a public defender office with all defense attorneys in general is that you can indict a ham sandwich. That's how low the threshold is. But we know in the Black community, for some odd reason, it's almost impossible to indict a police officer, yet we can indict a ham sandwich. And I want to bring that up because when you prosecute somebody, when someone goes to prison, when someone is convicted, they are convicted, we the people of the state of New York. And the reason why is even though we have a judge, a prosecutor, and a defense attorney on the panel, one of the important parts of the whole system is the grand juror, because you vote on indictments, you true bill what people are convicted in and can possibly plead to. As a person who's been on grand jury, you can imagine when a defense attorney gets on a grand jury, how prosecutors hate that. Because I am asking a lot of questions. I am talking to my grand jurors. I am telling them that the standard is not as low and we have power here because we are the people. And you want to ask, like, why is this here? How did the police officer get here? Is there's a confession? How did you get this confession? And one thing I do want to highlight is that when you're a grand juror, it's from 9 to 5, but a lot of grand jurors would tell you that sometimes a prosecutor will present evidence at 5 o'clock and you'll be like, well, I got things to do. I can't be here. And I think that's, then you want to true bill it because you're like, well, another juror will see this. And you want to know that almost 90% of cases in criminal court are pled to. And I think that's important because that means what's on the indictment, they can either plead to the indictment or plead to a lesser included charge in the indictment. So the indictment's such a powerful piece. And, by day 3, when I caught on to this, I was like, it's 5:30, we're leaving. If you can't present anything, we're not going to hear anything. And we have the power to leave after 5:30. So you're going to have to present this the next day. And that made a difference on how we voted because we're not voted thinking like people have to go places and things have to get done. And I think that's really important when we talk about what happens after you are arraigned. They have 5 days to present a felony complaint to the grand jury. And if you are remanded, that means if you are arrested, they have 5 days to do that if you weren't given bail. Now, obviously, with great bail reform, a lot of things have changed, but the first rendition of bail reform were way more pro-defendant. They have already modified bail reform because police officers and prosecutors thought that it was too generous and that judges weren't allowed to put more cash bail options. Now, I do want to say that it's still way better than it was pre-2019, but it is a leading defense community, primarily public defenders who are pushing like, this is what's happening. We're talking about Kalief Browder. We're talking about all these issues where people can't make bail. And it's, sometimes a very nonviolent offense. And I think that is important that we know that many of the crimes that are in any of the 5 boroughs, most of them are misdemeanors and many of the felonies are nonviolent offenses, yet people are sitting pending trial prior to bail reform. So I think that is something people should really be aware of. And a public defender office, unlike some private attorneys, come with investigators, come with social workers. Social workers are so pivotal because when you plead a case, we're going to prepare a pleading memorandum where we're going to have the social worker talk about who you are as a person, because a lot of these sentences are ranges. And we want you, if you're going to plead, and we want you to plead to the minimum sentence. Now, obviously, Ron was talking about these large ranges. Those don't happen anymore. I think when I look at my old cases, those sentences were really severe, really long-winded, and you're going to get hit by parole. So even if your minimum is a 7, they hear that you killed an officer or correctional officer or whatever, you're going to get hit by parole. That means you're not going to get released at 7. You're going to get released closer to 21. But now we have shorter sentences and we still try to fight and make sure they're the minimum as possible with social workers doing pre-pleading memorandums. So that's something that actually happens a lot during pre-trials because most of these things do not go to trial and most of them are pled out. And these are some of the techniques we're hoping for dismissals, meaning like, can we get it out of, can we get no true bill so you're not indicted? Or does the case dismiss because people cannot prove their complaint? So that's just some of the things you should keep in mind.
Lorna, you just educated all of us. Thank you for going through that. And I think one of the things that there are a number of questions that have come up on the chat and through the Q&A, so keep those coming and we will make sure we get to them all. I want to turn it over to the DA to talk a little bit about, you mentioned this as well, like how to present yourself as the person you are. So it sounded like from Ron's story that one, he was, it sounds like from actually what you said that currently people aren't being able to have that intimacy because of COVID, but also from Ron's story, there was a stigma that was attached to him because of who passed away, who died in his case, having a title. And so therefore there was already a stigma attached to what he did. How do you help create that personhood that Delorny talked about so that you're being represented and looked at and reflected upon in your whole self, including the person that may be on the opposite side of the crime? You're on mute.
It's the most important question, is how someone is being advocated for. And it's one of the things that as a prosecutor is the hardest thing for me when I'm reviewing the facts of a case. You know, the charge historically has been a very important piece of deciding what should happen with the case. But I've been telling the assistants in Brooklyn, we're not here to process paperwork. We're here to do justice and to look at who the people are before us. That includes what happened to the victim, or what was the harm caused by the crime. If it's not a person, that was there significant harm to a community? And who is the person being charged? Who is the accused? What do we know about them? And in this process, and even in the process that we were hearing about in the grand jury, unfortunately, there's very little information early on in the case. There's so much rush to get the process moving, get due process started, that when you go into a case as a prosecutor, even as a defense attorney, you know so little about your client, you know so little bit about the person who is the accused, and you're really just talking about certain facts without really an analysis of what and who this person is. So this is why I said that early on in a case like this, before an indictment is procured, the ability to try to communicate with the prosecutor who's handling the case and get some information about who the person is. One of the, I think, benefits of not having bail in all of these cases, there's no longer the rush to get to the grand jury, because as we just heard, you have 180 hours or so, that includes weekends and holidays, to present the evidence to a grand jury. And so if you are rushing, you're going to make mistakes, and bias confirmation and other problems cause us not to see who the person is. So the key here for everyone is letting both sides, both the defense side and the prosecutor side, know who the person is, that we're making an assessment on the person and not the charge. I think that's critical in pursuing justice, and it's something that we are working on very much. So those PPIs that we heard about are so integral to let a prosecutor know as much about the accused as possible. Remember, prosecutors are not allowed to speak to the defendant. And so the only information we're going to get is from the defense attorney. However, and we talked about this on the first one, this is a place for all of our stakeholders, our community leaders, our clergy, our community to reach out and let us know who the accused is. It's very powerful to me when I get letters from community members, I get members from clergy, I get members from teachers and other community people who say, I know this young man, I know this person, DA, he's not the worst thing that you just read about him on this case. He's actually a good person, and he's deserving of an opportunity here. Those are critical. So there are things that the congregation can do in advocating as well. Now, obviously, I would say you want to run that through the defense attorney, of course, because you want to be consistent, you want to be helpful. But those letters are much more impactful than any of you would probably realize. Because when I'm making a decision as the DA, I represent the community. And when I hear from the community that this young person or this person deserves an opportunity, a second chance, it's meaningful. Because obviously, the community is the one who also suffers with the harms that are caused by a lot of crime. We all know, and we've all experienced crime in our life. There's very few people have never been a victim of a crime in some way. We want to make sure the justice system is also keeping us safe, but we do want fairness and we want to be treated equally.
I thank you so much for that. And I really want to emphasize what DA Gonzalez said, that the community has to play a role. So whether you are on the side, like if you're in Ron's situation, sharing with the community what you're going through so that people can advocate for you in the community, but also if you are a member of the community, think about how you can write a letter. Everyone has pen and paper, write a letter, reach out, make a phone call. You could be changing someone's life. So I want to pivot a little bit and bring Judge Betty into this conversation. Judge, how do you look at this type of scenario, but from a family court standpoint? Like if this was something going on in family court that touched upon either children welfare or a family, what differences do you see? And then what, again, from an advocacy standpoint, what do you recommend?
Okay, well, first of all, let me also say thank you for putting me in this discussion, even though I don't have the quote criminal law experience that the panelists have. My experience in family court has to do with juvenile delinquents, also domestic violence, but juvenile delinquents particularly. And I will say that a lot of what happens before the stage in criminal court is different. When a young person is arrested, and a young person, let me just say now, the jurisdiction before 2019 used to be 8 to be prior to 16. Now, because of the raise the age, it is up to under 18. And it's my understanding, because I'm working with Craig, Judge Walker, who is in the youth part, that all of the felony cases for age group up to 24 now go to the youth part instead of the criminal court part. And all of the cases that are misdemeanor now go to the family court up to 18, before they're 18, 16 and 17 years old. But they come into court and right away there's a effort to resolve the case, to do the adjustment, to divert the case before it even goes to court. But it has to be with the consent of the victim. If that happens, then the case goes away. If that doesn't happen, that's when the petition is filed. It's called a petition is filed, and that's a respondent, not a defendant, that comes into family court. And up to that point, there's a lot. The goal of the family court is not punishment. The goal of the family court is the best interest of this young person and the protection of the community. So it isn't all of this. It seems to me, even though the prosecutors in the family court, the assistant corporation counsel, because these cases are filed by the corporation counsel, they seem to have the same goal of putting our young people in some sort of placement. They seem to have that. So the struggle of the attorneys for the child, which used to be law guardians, the struggle of the attorney for the child is the same as the struggle that the Legal Aid Society has on the criminal side. But we have many more resources in family court. That is why even before raise the age, when a child was arraigned in or sent, initially sent to the criminal court, there used to be a motion for it to be removed to the family court because they know that the family court has many more resources, and those resources are supposed to be put into play at the very beginning. And as the district attorney said, this is a stage. The first stage is an important stage for families to know you must go to court with your child. You must be present for your child. Because if the child is appearing before me, if there's no one out there that I can rely on to send this child to, what choice do I have? So participation, and it doesn't have to be a parent. It just has to be an adult who is responsible that that child can go to. So key, go to court with your child. Even though I've been off the bench many years. Oh, by the way, let me correct something. I didn't retire in 1979. I graduated from NYU in 1979. I actually retired from the bench in 2006, and then as a AFJ in 2011, when I'm the president of Legal Services now. And just a plug to the DA. Thank you, DA, for always coming to our aid when, even as the civil case, sometimes we have criminal matters like fraud and age theft and other things at the district attorney's office. But in terms of the juvenile cases, up to the time of arraignment, at arraignment, they can be released to a parent if a parent is there, and that's why it's so important. And that's the difference. And I'll discuss any other kinds of disposition if you want to at a later time, or do you want me to do it now?
No, I think this is good because we're talking, you really emphasized again that participation and advocacy and how important that was.
Can I say something, Mrs.
Sure.
Johnson? I think it's such an important thing that Judge Staten just said, because it's relatively new and most people probably don't realize it. The district attorney's office no longer handles cases when the child is 17 and under and charged with a misdemeanor. Those cases automatically come to family court. We don't even screen those cases anymore. When the arrest is made, the DA doesn't even screen those cases. And in terms of the felony charges, where they're more serious cases, those go to a very specialized part. It's called the youth part. That youth part is done by Judge Walker, who's doing a fabulous job for the people of Brooklyn, by the way, here. And it's a combination. He sits as a family court judge and a Supreme Court judge. He has dual jurisdiction with the goal of my stated goal as the district attorney that these cases go to family court. I was the first DA to support raise the age. So we have the highest percentage of these cases going to family court. So 93% of the eligible young people in Brooklyn wind up being handled by family court. So most people think that the DA is handling these cases. You know, what's the DA doing on this case? We're not involved in most of these cases anymore. So quite frankly, when we keep control of a young person, they're charged with a very serious crime. Usually it's going to be a shooting, a homicide, or a sexual assault. Robberies and other things go to corporation counsel. So that's a complete change in the system. And I think people are surprised to hear that. I think it's better for the young people for the reasons Judge Staten said, and I still think it will keep our community safe.
And let me just add, thank you, District Attorney. That happened after I left the bench, but I do know a little bit about it because I've talked to Judge Walker. He also said that in all of the years that he has been presiding in this youth court, none of the cases have ever gone to trial. There is a resolution in the case, and if there, and he has many resources. He has these alternatives that the young people can involve in, and if they complete that, okay. Otherwise, it's a youthful offender. A youthful offender disposition in the case is never, they're never convicted in the way they would be convicted if they were in the criminal court system. It's a youthful defender even if it comes to the point where the disposition is a finding. There's no finding of guilt or whatever in the family court. There's a finding that the young person would have committed a crime of a particular thing if they were an adult. There's no finding in the family court against a young person. And so it is that the person is found that if they were an adult, they would be found to have committed whatever the charge is. But there's no guilt or no finding of guilty.
Thank you so much. I want to ask one more question before we go to the audience Q&A. So for our panelists, this will be a rapid fire response. But we've been talking about advocacy, and we've kind of highlighted some of the places that people are most vulnerable if they are caught up in a criminal case. And one of the things that always hits my mind is that area of discovery and when you get information and how you know what you're up against. I'm hoping, and I'll point this to Sherry first, when we think about excessive sentencing, when we think about pretrial information, can you talk a little bit about the most vulnerable places that people should be aware of and advocate for themselves? Like if you don't feel like your attorney is covering you well, what do you do to get a better attorney? Or what, if it's legal aid or provided attorney, if you don't get the right information during that period that DA Gonzalez talked about, where you receive the charges, it sounds like some information sometimes gets shared, but not everything. Like, how do you advocate for yourself, and what places are the greatest vulnerabilities?
Well, I think from my experience, what I can say is that a lot of times the person, when they come to court, if they feel like their attorney isn't, providing them with the proper services or explaining things to them, a lot of them will say it in court during a court conference. So, and I think that might be, a difference just because it's Essex County, and it's a largely you have a large pool of, minorities and Black defendants that are there. So I think what I hear from colleagues in other counties, and as well as defense attorneys in other counties, is that the best treatment that people, or the most fair or humane treatment, I would say, that a person gets is in Essex County for those reasons. It's, the largest, Essex County is the largest prosecutor's office and the largest county in the state. And we handle, I think roughly around like 25% of the crimes in the whole state. So it's a little different in Essex than it is in the other counties. So I think a lot of people know that in this, general part of like the general information. And so also what happens as well is that during these court conferences, when people are coming to court, we have to, and I mentioned this before during the last meeting that we had, you have to say as a prosecutor what the proofs are and, like what that discovery is. So when I, for instance, when we first have an arraignment, my judge will ask, okay, well, have you turned over discovery? And, answer yes, no, and, well, what is outstanding? And so all those things are put on the record. And I feel that that's, a very transparent process. And a lot of times, people will just blurt things out. So a lot of times you'll know what's going on and whether that attorney is really doing what providing the best service to their client. But I can generally say, though, I think in Essex County, a lot of the attorneys are very good. We have, good working relationships. As long as I've been doing it now, certain people, have cordial relationships with them. And I always say the attorneys will be good about providing certain like letters, as was mentioned earlier, from the community, from their jobs. And then, it does make a difference when people come to court with their families as well. So I can just say that I think it's probably the best in Essex, from what I've heard from other people as they practice in other counties.
Thank you. And DeLorme, I want to ask you the same question. Where do you see the greatest vulnerabilities for people who are facing a trial, maybe in that pre-trial stage or other places, and what can they do to advocate for themselves?
So I would say we have our criminal court system is two systems. If you have family, if you have support, whether that is a church or whatever, you're gonna get those letters, right? You're gonna get advocacy. I'm gonna have options as a defense attorney to portray you as in this good light, if that's my strategy, right? Because we also know that the criminal court system is based on lots of law. I became an appeal attorney because I really wanted people to listen to the law, regardless of what the crime was. There's these steps, and people need to follow these steps when you're investigating, when you're processing, when you're prosecuting. And I just was like, no one's listening to the steps, because like Ron was saying, that you're like, well, you killed somebody. Well, we found the gun. And like, well, hello, like there's steps to the evidence here. So I see that happens a lot. But when it comes to advocacy, most of the system, which is nonviolent offenses, if you add the misdemeanors as well, are homeless people. They don't have a community. They don't have nobody. And maybe they're mentally ill or drug addicted. So they have a long history of crimes that, yes, they're petty offenses, but it's a long history of crimes. And, Brooklyn has some great divergent programs, meaning there is drug treatment court when we talk about pretrial. There is mental health court when we're talking about pretrial alternative to incarcerations. But and you're going to see your client, you're going to be like, there's these things called busting by. So the police officer did find the drugs on you, and you're going to ask them, can we get you into a program? First of all, it's not always every defendant doesn't qualify for the program despite, his addictions. But let's just say we get you into a program. We already know drug addiction is a medical complicated thing. The prosecutors have a law degree, defense attorneys have a law degree, judges have a law degree, and we're talking about a medical concern. And that is really complicated for the systems we work in, right? There's a timeline for these things. And we do have judges that are going to give you some leeway to, get it together. But eventually you run out of chances, and you've been deep in heroin for God knows how long. And this system is not going to get you clean, unfortunately. And if we can get you mental health compliance while incarcerated, you got to go out to the community. We don't have enough supportive housing. We don't have enough of these things. So when we talk about advocacy, I'm happy I'm talking to a community, because the defense attorneys and the prosecutors, we're going to try everyone's going to do their job to the best of their abilities, but the law is the law. So if you get criminal possession in a 5th degree, this is an E felony, a very low level drug offense, and it's based on possession, you might get into a drug treatment. But if you don't pass that program, even though it's a nonviolent offense and everybody can tell it's based on your addiction, if you don't finish the program, the alternative is incarceration. And there's not a letter or anything I can do. The statute is the statute. It is what it is. And, as New York City, as both Judge Stason and Eric Gonzalez said, we have done a lot about discovery reform. New York State had the worst discovery reforms, and therefore people were pleading to things and they didn't have all the facts. That has changed. Bail reform means that my client can wait until I get the discovery, because the discovery is not coming on day one. So I need some time to get that discovery. We can look at it together. We can talk about what our strategies are based on the discovery. This is a new lay of the land in criminal court. And it wasn't easy, but we're here, glory be to God. And I think that is making a difference. But at the end of the day, there are some drug charges that are on the books that we as a community be like, if we already decided as a society addiction is a medical concern and not a crime, then maybe some of these things that are on the books should go away. And in the meantime, grand juries should just no true bill it. So.
Yeah. No, I thank you for that. I mean, this idea of us needing to connect the legal system to mental and social services is pervasive. And I think everyone here, as both constituents of a community and voters, need to make that a priority in the conversations you're having with your political leaders to help encourage that to be a policy change. I want to just for 1 minute, give Judge Staten a chance to weigh in on this same question from family court. And then I promise we'll hand it over to Minister Jocelyn Mann so she can take us through some of your questions. So Judge Staten, what do you see as those vulnerabilities in the family court system, and how can people better advocate for themselves to have the best outcome?
Oh, well, the vulnerability for our young people goes way back. If you heard about the school to prison pipeline, there is a foster care to prison pipeline. There are all of these things that are facing our families and children. And so they're vulnerable. They're vulnerable because of racism. The cases that came before me, I never forget. Every case that came before me, the ACC wanted to send our children to remand, but if it was a white kid, they always could go home. So they're totally vulnerable. From the time they're born, I mean, it's made out. If they don't have the right family, the only advocacy that young people have, well, they have sometimes teachers, they have coaches and things, alternative activities. They have churches if they're involved in churches. And those are the kinds of support and the way they can advocate. They can't advocate for themselves. The community has to advocate for them. Their family has to advocate for them. But our children are, and now with this pandemic, when many of them haven't had any schooling in a year, this is already a setup for the next 5 or 10 years in prison. I mean, what are we going to do about that? What are we going to do about all of the things that are affecting our children and sending them right to prison?
Wow. I mean, you just summed up powerfully exactly where we all need to keep our minds. Again, every election, every call to your community leaders, writing letters, it really is about the coaches, the teachers, the community leaders playing a bigger role, because we are at a disadvantage as people of color, and we can do more to support one another. So I thank you deeply, Judge Staten. I'm going to hand the floor over to Minister Jocelyn Mann so we can ask some of your questions to our esteemed panelists.
Hello, everyone. If you have questions, please submit them either via the chat or through the Q&A portion. The ones we have received already, is there a specific time for an appeal to be heard?
The answer to that is yes, but I'm going to let Delony talk about it because that's what she does for a living. It is a very frustrating appellate situation, I'm sure for the defense and for the prosecution, because often it may take years for an appeal to finally be decided. But I'm going to let her answer that.
Yes, there is a time frame. So one at the Legal Aid Society, and I think most of the public defender's office in New York City, they all do notice of appeals, meaning pretty much whether you even ask for one or not. I think Eric Gonzalez knows, we get appeals for everything. And, you know, just because Eric Gonzalez, he also has an appellate unit that does the appeals that are by opposing counsel. They take, I want to be honest with you, about 18 months. We have to, get the record from the court. That's slow. And then you have to find an attorney who can actually do it. If you went to trial, which is becoming less and less, and I think because of the pandemic, it's either going to be like we have no trials. A lot of things have been pled out. You have to collect all the evidence. And someone brought up excessive sentence. And sometimes we just even do defense counsel. We just do an excessive sentence appeal. So we try to appeal everything. That means even though there wasn't an error in the law, because like I said, everything needs to happen according to the law. And sometimes there are errors, even with a plea. We can find some substantive errors in a plea. But if there isn't an error, we can just say he didn't receive he, she, or they, whatever pronoun, didn't receive the minimum sentence. And we make those arguments, and the district attorney of Brooklyn will tell you, sometimes we win. Sometimes we get a minimum sentence because, especially when we get those pre-pleading investigations, meaning that there was something the social worker or somebody wrote up that's on the trial level, I'll use it. There's also something called a pre-sentence report that can be very beneficial, that every defendant who, even when you plead, talks to a probation officer, and therefore, you know, we use that in an appeal, but I would say 18 months. If you went to trial, maybe even a little bit longer, but as long as you get the notice of appeal, the courts are not going to throw it out. It will be heard. It will be heard. So yes.
Thank you. Thank you. I know we spoke a little bit, a little while ago about medical issues is dealing with addiction. This question says, what steps can you take when someone is incarcerated and is having mental challenges? And the person is also confined to segregation for almost 7 years. Is there anyone who wants to take this?
I'll give it a shot, but it's not, quite frankly, you know, I'm not an expert on what to do when someone is incarcerated in upstate prisons, sounding like for upstate time on this issue. But we need to make sure that there's advocacy on that issue, right? There is some current legislation right now that I encourage everyone to take a look at to confine sort of segregated housing or, you know, solitary confinement on issues with people with mental health issues. You know, what we do in Brooklyn, which is what I'm more comfortable with, is that we actually have a very stellar mental health court in this county. And there's different processes by which a person who has mental health who come into the system, which is an increasingly large number of people who come through the system have some mental health issue. Our mental health court can work in different ways, but you know, what we try to do is make sure that the person receives treatment, is stabilized, and we want to restore them back to the community, right? We want to make sure that if they're in jail, when they get out, that they have the resources and the supportive services to make sure that they are not a danger to themselves or to anyone else, and that we're working on stabilizing people. And if medicine is necessary to assist on that is being done. And in a lot of those cases, upon completion, and I think this is critical, upon completion of services, the goal is to either dismiss or not keep a criminal conviction because the collateral consequences, we all know what they are. I'll say them quickly: housing, education, employment, and other things that once you're a convicted person, it's much more difficult to be successful in life. And there's a lot of, there's a lot of people who will use that against you. And in terms of a non-citizen population, it could lead to deportation. So that is what we try to do in Brooklyn. When we have severely mentally ill people who we do not believe can ever be stabilized, they will often, and I'm willing to allow them to plead not guilty by reason of insanity, what we call the NGRI pleas. And that's a very complicated conversation that we should do at another time. But there you have mental health officials who get involved. The person will go to a mental health hospital. They will be there for a period of time, and then within a specified period, they will have an opportunity to be released back into the community. And the courts are involved in that, and mental health lawyers and a person from a prosecutor's office or another agency will also be part of that. So people with significant mental health issues that can't be sort of addressed by medicine or some kind of therapeutic sessions really will wind up in the hospital. And then it'll be up to the hospital to decide when they're safely released and sent back home. So I think that's what we do. I don't know if that 100% answered your question. There are lawyers who specialize in this, and if someone is asking because they have someone in that situation, I'll make sure that you reach out to me and we can figure out some sort of attorney or pro bono or legal aid or BDS or whoever can maybe try to assist.
Thank you.
I'm just gonna jump in a little bit. One, yeah, Legal Aid does have a prisoners' rights project, but there's also prison legal services. I just want to throw that out there. They are located upstate and they specifically focus on inmates, people who are incarcerated and what they need. Additionally, Department of Correctional Services actually does have I cannot believe I'm saying this, they do treat mental illness and try to stabilize your client. And I do understand the difficulties when you have someone who's severely mentally ill and violent, which we see that with bipolar, schizophrenic. A lot of them get violent, and those have less options when we get to criminal court. But if the person's already upstate and serving time, Department of Corrections by law has to comply with the Office of Mental Health, which oversees all people who are incarcerated with severe mental illnesses.
Okay, thank you, Lonnie. I'm sorry. Thank you. I have a couple of questions surrounding Ronald Logan's case. One from Barry Rollins: how much of the record of the shot individual can be introduced at trial? Or I should say, or victim can be introduced at trial?
On a self-defense case, a lot. I mean, on a self-defense claim, you know, there's a lot that can be said. You know, I think on the issue, and I'm not sure, you know, Mr. Logan is still on the issue. You know, what was unclear to me was whether or not, you know, the deceased was trying to take law enforcement action, because I think Mr. Logan said, do you have he asked him if he had a gun on him, and then there was sort of an altercation. But in general, when a person is claiming self-defense, anything that they know about what they have personal knowledge about of the person they're in the altercation with. You know, I've tried a number of cases that involve self-defense, and when there's a history between the parties, when someone has to explain why they made certain decisions that seem to, you know, and the use of force, anything that they know about things that the person has done in the past that may, or altercations they've had or disputes they've had, usually all of that should be admissible. It's a little more complicated when someone, you know, the decedent history, let's say for drug use, and the person on trial didn't have firsthand knowledge of getting some of that information in, because it's considered collateral. And I think Mr. Logan also said in one of the chats that he was also sort of responsible because the gun he had was illegal. He didn't have a license for it. So that, you know, would not be a defense to the charge, you know, of the gun as well. So it's complicated, but in a normal self-defense claim, you're going to get more of the person's record. In another kind of case, let's say it's not self-defense, it's a robbery, or it's, you know, some kind of dispute, and there's no self-defense claim. The claim is, I didn't do it. Then, because you're claiming that you didn't do it, it's less likely that the judge will allow you to get into some of the underlying background of the person who was killed.
Okay, thank you. I have another question for the panelists. Was the off-duty court officer in his right to go after Ron in the manner that he did, since he never made Ron aware that he was a court officer? Was he right to go after Ron in the manner that he did?
I'm going to say no. I'm going to say no. He's a law enforcement official. He wasn't on duty. I don't know if he had his badge or didn't have his badge. In that case, he probably should have called 911. I mean, I do want to, you know, obviously the loss of his life is still significant, and I'm not diminishing that, you know, he lost his life and is not here, you know, many years later. But we should be responding appropriately. And if he was drinking, and he should not have even had his gun with him at that point.
Thank you. Another question: would Ron's case have been handled differently if the initial arraignment had been manslaughter instead of murder, and also his sentencing?
I think it's hard to say. The maximum probably that he was facing at the time was 12.5 to 25, Mr. Logan. These sentencing laws don't exist today. The sentencing laws had changed, you know, many, many years ago. So these kind of scenarios that we're talking about, the time frames are just completely different. but he was facing a maximum, I believe, at that time in 1986, which I was still a very young man back then. He was facing a maximum of 12 and a half to 25. He pled to 7 to 21. That is on the, I would say, mid to low range mid of a manslaughter plea. I think the minimum back then on the manslaughter might have been 5 would have been the lowest number. So it might have even been as low as 3.5, but it was on the mid to the low end of that plea. It was not on the high end, which 12 and a half to 25 would have been on the higher end of that. I think the real problem with Mr. Logan's case wasn't the first number. It's and he spoke to this very eloquently, it's the problem with our parole system that he had served his minimum. He should have been up before the parole board. They should have made an assessment on who he was as a person. Obviously, they're going to look at the harm caused by his action. Another person lost their life, but was he doing well in prison? Had he done everything he could have done to turn his life around and to make the best out of the situation that he was facing within jail? And was he safe to return home? And as a number of the panelists have said today, in parole, sometimes they get stuck on what you did and not on who you are and how you have changed your life during that period of time. So they kept him a long time, but even though he had been eligible to be released after 7 years, and that is the shame of that program. It's one of the reasons why in my office, I support less is more, and I've taken a different position on parole and probation. I've worked very hard with some of the lawyers in my office to have a parole and clemency unit. I'm the only DA in the state that has that, and we've written at this point nearly 150 letters asking parole to release people who are currently upstate. For all of you from Brooklyn, you should know that 1/3 of the people upstate in upstate prisons on 25 years or more come from Kings County, Brooklyn.
Thank you. Trying to see if there's any more about Ronald's case before going to the others. Ron, did you want to say anything? Did you want to weigh in?
They was mentioning something about the mental health person incarcerated that has been segregated for 7 years. And I know for a fact, for one thing, you segregated in the correctional facility, you are locked in a cell, basically by yourself for 24 hours. You have 1 hour of recreation, which is in another cell, or maybe a yard by yourself. So you have no interaction. So somebody that has mental health issues with no interaction, and maybe you have a counselor walk by them occasionally and speak to them once a day, that's not really good for somebody with a mental health issue. Yes, they were given their medication, but still somebody with mental health issues need to have one-on-one. They need to have somebody to talk to. They need to have somebody to interact with regardless. And they don't get that when they're incarcerated. So somebody that's been incarcerated for 7 years, has been confined 7 years with a mental health issues really, really, really deteriorating.
Yeah. Solitary. Thank you, Ron. I have another question that came up. Did Ron have the right to return fire after having been shot, considering the court officer did not identify himself despite the fact that he was carrying an unlicensed firearm? Or does the fact that he was carrying an unlicensed firearm trump everything else? DA, I think you're muted.
Sorry. So under the law, a person has a right to defend themselves from unlawful use of force, right? So let's forget about Ron's case for a moment and just say you're a store owner, you have an illegal firearm in your store, and someone comes in and tries to rob the store at gunpoint. The store owner can use their gun to protect themselves. If the robber is trying to shoot them, the store owner can also use that gun to shoot back and to protect their lives. However, under the law, the store owner is still chargeable for the illegal possession of the firearm. In New York, there are different rules about gun possession and illegal gun possession. It's less of an offense if you have the gun in your home or place of business and it's illegal, and it's treated more harshly if you're in possession of the gun unlawfully on the street or in a public place. But so to Ron's case, yes, if someone is shooting at him, he can return fire, but he's still criminally liable for the shooting the person with an illegal firearm. Obviously the question in Ron's case, on the manslaughter charge was, was he in fact acting in self-defense? And that was a question that was the ultimate decision that the grand jury had to make, initially for the charging cases, and then ultimately for a trial jury. It never got there because it was a plea bargain.
Thank you. Thank you. I have a question from an anonymous attendee. When a young person is arrested as a young adult, can they call their parents? And I think that question, correct me in the chat if I'm wrong, they're talking about thinking about their age. So they're a young adult, but they're still considered adult. Are they legally allowed to call their parent?
Not only are they legally allowed, it's legal that the parent should be there.
Mhm.
You should not even question a young person without the parent being present.
Thank you. Thank you. Another question that came up earlier is, what happens if you cannot make bail? What are the recourses if you cannot make bail?
There are bail funds. I know those became really popular, like viral during Ferguson. I mean, not Ferguson, but just most recently in 2020. Bail funds have always existed in New York City for some time now, I think in the last 3 to 4 years. So there are applications that can be made. Most defense attorney, Legal Aid has a whole decarceration unit that works on partnering with bail funds to pay that bail based on specific factors that the bail fund may have, and they can put it up. But if the bail fund won't pay the bail and you don't have bail, then you are remanded.
Thank you. Okay. I have a question. Please speak to the importance of people understanding the structure of the grand jury. There's no defense counsel present, and there's rarely any challenges to what's being presented. Please elaborate on what that means. What that means, that a ham sandwich can be indicted. Thank you.
That means it's because there's no one there a lot of times, and the instructions are like, this is not innocence and guilt. They'll see eventually a trial. When 90% of cases never see a trial. So the standard is so low, people think it's nothing it's frivolous to true bill something, which is mean to indict a conviction, and you have to indict everything. So for example, Ron had murder and manslaughter. When you are voting as a grand jury, you're voting on every single one of the charges. So you can be like, no to murder in the first degree, yes to manslaughter, because it is a vote. It's also sealed. And we know this because with the police officers, a lot of people are asking DAs to unseal the grand jury. It's a sealed thing, meaning, so when I was a grand juror, I did see, so the defense is invited to a grand jury. I don't want to take that away. They are invited to a grand jury. When I was on grand jury for 2 weeks, I did see a few defendants there. It is a legal strategy not to go to the grand jury because that evidence can be used against you. If your defendant says one thing at grand jury and then says something else, then we have all these cross-examinations. Defense attorney cannot cross-examine or question their defendant. So it's just for the grand juror to ask questions. You are the attorney, and you can be whatever type of attorney you want. You can ask no questions, a lot of questions, helpful questions, but these are just regular people. I was sitting next to somebody who works at the Mac store doing makeup, right? These are just regular human beings. They are overwhelmed when they see a prosecutor and they think, well, whatever, it's my day off or whatever the case is, I had to be here. What's the big deal? Let's just get the show running. But I am telling you, the people of Kings County, Manhattan County, Jersey, wherever you are, it's a worldwide thing. The system was created to put you at the center for felony cases. And therefore, I encourage you to ask some questions. And if you don't like the questions, then do what you do. And if you don't like the charge, also do what you do. But you are empowered and no one can punish you. And I think that is something when we're talking about regaining your rights. So I want to add that.
And I just want to add to that is that for those who have no idea what a grand jury is, the grand jury usually has around 23 people, should have at least 16 at the time, but witnesses are being called. So the prosecutor is in the courtroom. It's really a courtroom in Brooklyn. It's just a courtroom. They come in, the witness sits. So witnesses are called, civilian witnesses and police officers. There's some, if paperwork needs to be put into it, some paperwork could be admitted, scientific evidence. And it's a hearing to decide whether or not the arrest that the police made and the charges that had been decided, that are being offered to the grand jury should be voted on to see whether or not there's reasonable cause to believe that a crime was committed and that the case should move forward, right? And so to the point is, the reason why it's considered that a ham sandwich can be indicted is that in most cases, only the witness will testify. So the witness will come in and say, I was walking home and the person snatched my pocketbook and ran away and I fell and I got hurt. And so that's the only evidence that the grand jury hears, and minus anything else in most cases. And I would say the overwhelming majority of cases, without any critical analysis of anything else, that person will be indicted, right? Unless, there's some other evidence. Juries can ask questions and juries can refuse to indict cases. And it happens in Brooklyn, but the overwhelming majority of people wind up getting indicted. It's one of the reasons why when a judge swears a jury to actually try the case, they say the indictment is not evidence of the crime. In the old days, I used to see prosecutors take the indictment and read the indictment to start the trial, to sort of suggest to the trial jury, some other jury has already found him responsible. And that is a practice that's disfavored, and I think most judges in Brooklyn don't allow that anymore. So that is the thing. An indictment is it more likely than not, which is really the standard, reasonable cause. Is it more likely than not a reasonable cause to believe that this person committed that offense? And without any evidence to the contrary, usually the jury will indict. However, in Brooklyn, and I think interesting in the conversations that we're having around racial and social justice, if the only witness is a police officer, sometimes the jury is less likely to indict those cases. And we see that happen in Brooklyn.
Thank you. I'm passing over to Reverend Trufant.
I want you to know that I am grateful to God for the panelists. This panel was informative. It was encouraging. It was encouraging to hear that there are people who, on both sides of the case, as well as behind the bench, who are concerned about making sure that people of color in general and Black and brown people in particular receive due process, receive the resources that they need to get better results when they interact with the criminal justice system. So I thank all of you. What is more, I want to point out that I have a suspender popping moment. With the exception of the DA, all the members of the panel were members of EBC. And I want to thank God for a congregation that is gifted, a congregation that is involved in not only what's happening within our church, but more importantly, what's happening outside of our church in the larger community. In particular, I want to take my hat off to Ron. Ronald Logan shared his testimony with us. He was very open, transparent, and vulnerable. And I want him to know that I thank God that he's opted not to bury the experience or simply try to distance himself from it, but to mine it and draw from it insights that can be of help to others. And so thank you, Ron, for sharing your story. It is a powerful, instructive story.
You're welcome. And if I may say something, that
Sure.
EBC was very helpful to me. Do you know that from the time I came to EBC, like a month after I came home, and I started reconnecting with some of the members that I knew before I went away. And it's through EBC that I started working as assistant case manager 89 days after coming home.
Wow.
So EBC has been very, let me tell you something, man. I gotta give all praises, okay? And anything I could do for EBC it's an honor. Trust me when I tell you, it's an honor.
Well, Ron, you have just offered evidence of what I've often said about EBC. If you don't come for any other reason, come for the hookup. We have people in every walk of life, every profession, and we have people who are willing to extend themselves to be of help to others. Speaking of extending themselves, I want to thank both Jocelyn's, Jocelyn Walters, the head of Impact and who was our host, as well as Minister Jocelyn Mann, who is always the hostess with the mostest. And so I appreciate what you share with us. And then Catalina, whose face you did not see, but whose presence is indeed felt because she is the person who's handling the technical end of things. And so Catalina, thank you. And then I also want to mention two people who are not present, and that is Renee Jarvis and Charlotte Johnson, both of whom are on my staff, and they were instrumental in marketing this experience. So I want to give them credit because I believe in giving credit where credit is due. And then finally, I just want to thank you, the participants, for being present, for carving out the time, for listening actively, as well as thank you for what I believe you will do, and that is to bless somebody else with the information that you have received on today. And then finally, I want to thank Reverend Stefan, who will be giving us our benediction in a second. We will have the third and final conversation in May. And I want to ask that you mark in your calendars, pencil in the first Saturday of May. And at that time, we will be covering from the trial to doing time. From the trial to doing time. And we're also going to spend some time talking about what it means to return to the community and the resources and services that need to be in place, but also the attitude that the community needs to have for persons who are returning to the community. I read a case very quickly, two articles I read. One was on Lydell Grant. Lydell Grant is a brother who was accused of murder. He did not commit the murder, yet there were multiple people who identified him as the killer. And his lawyer did not ask to secure DNA. As a consequence, he was found guilty and wound up serving extensive time. He spent time in the law library trying to clear his name. He filed appeal after appeal and exhausted his appeals. Was on the verge, rather, of exhausting his appeals when the Innocence Project stepped in. And they were able to recover the DNA and exonerate him. And the interesting thing to me in the midst of all of this is that even once they recovered the information, the DNA, they had to find a judge who was willing to hear the case because many judges were not willing to hear the case. They got turned down a couple of times. So I think that it's important to bear in mind that there are people behind bars who are innocent. I give you one more very quickly, and that is Tyra Patterson. Tyra Patterson interacted with the system as a teenager. She was 19 years of age, accused of murder. She did not commit, but she had the disadvantage of being illiterate. So when she was asked to look at some documents, to sign her name to documents, she did so, and the police who were interrogating her, who have, and I need to stress this, who have the right to lie to you while they're interrogating you, to extract information that's crucial to prosecuting you. So be careful about what you say. And if you don't have an attorney, it's advisable not to say anything until you get one. But this sister spent 23 years in jail for a crime that she did not commit. And again, it was the Innocence Project that stepped in and helped her out. So what I want to stress to you is a couple of things. One, EBC, out of our Mission and Benevolence Fund, will be giving a grant to the Innocence Project because we want to make sure that more people have an opportunity to benefit from their work, and their work is worthwhile. Secondly, I just want to point out to you, based on those two cases alone, you can see why it's so important to understand how the system works. And I just want to stress this. I think that sometimes, unless it hits our home, we don't think about the fact that there are people who are incarcerated who are innocent. And then there are people who are incarcerated who did the crime, but the punishment does not fit the crime. And then there are people who are behind bars, and we talked about this, they're behind bars because, to be very candid with you, during the Pataki years, one of the ways in which the budget of New York State was streamlined was that the state got out of the business of mental health. They closed down the mental health hospitals by and large, and they went to supposedly a community health model. Well, what happened shortly after they did that was that they start cutting the money to the community mental health centers. And so we now have a lot of people who are out on the streets who are part of the homeless population who were not being checked on, so they were not being medicated, and they wind up acting up and acting out, and they catch cases and they're incarcerated when they actually should be receiving treatment. So there are many issues for us to deal with, but I thank God that we have this partnership, and I look forward to talking with you further, but also to working on policy issues that will make a difference. So Reverend Steph, if you'll take us home, sir.
Absolutely. Let us pray. Oh, gracious and eternal God, we are just so thankful, so very thankful, very thankful, Lord God, for this meeting of the minds that has taken place, for this information that has been given to us as members, given to us as community members, Lord God. We are thankful for the time that we had, for what was shared, and for how we are going to carry this information forward, for how you are going to strengthen us and empower us, Lord God, to be more mindful of these things, be more mindful of the way that our system works, be more mindful of how we can assist in the process of helping others either navigate the system or avoid it altogether, Lord God. We just thank you, Lord God, for who you are. We thank you for, again, everyone that was involved in this process, from all of our panelists, Lord God, to everyone who attended, from those who streamed it on YouTube, Lord God, from those who were involved in the planning. We are just thankful for everybody's input. And most importantly, Lord God, we just pray that as we move forward, that we do in the words of Scripture, that we do justice, love mercy, and walk humbly with you. And when we do that, Lord God, we know that the best results for our community and our world will begin to take place. This is our prayer in Jesus' name. Amen.
Amen. I hope that you were blessed, and now I charge you to be a blessing to others. God bless you. Peace.